My name is Jeff Morgan. I'm from Dallas, Texas. I want to talk about a recent decision made by the Texas Supreme Court regarding the Jeff Younger case. And I've got two different videos I'm going to be doing on this right now. The first one, I'm going to be actually taking aim at Jimmy Blacklock, Clueless Jimmy Blacklock. And then I will be talking about Evan Young, the compromised Evan Young. Now this case, this was decided, I believe it was the end of December, last day of December, I believe it was. It's number 22-1137. You can actually find this online, but this was the opinion written by the clueless Jimmy Blacklock. And I'm very disappointed in Jimmy Blacklock. I've met him. I thought he was supposed to be a conservative guy. I thought he had a head on his shoulders. He is absolutely clueless in what he is writing here. And I'm going to just say something else at this point in time too. We can no longer give our conservative legislators, our conservative judges a pass. When they are clueless, when they are compromised, when they are acting more like communists than the Christians they profess to be, we need to start calling them out. The Democrats, by and large, you can call them out on everything, but when it comes down to the Republicans, they somehow think that, you know, we're conservative, we're on your side. You can't throw us under the bus. In situations like this, silence would be a sin to not talk about this issue. So here is the clueless Jimmy Blacklock, the clueless Jimmy Blacklock. He is on the Texas Supreme Court, Texas State Supreme Court, and this is his opinion regarding the Jeff Younger case relative on the petition for a writ of mandamus. Now, Justice Blacklock was joined by Justice Young, concurring in the denial of the petition for the writ of mandamus. And let me say right off the bat here, I'm not an attorney, so I'm not a lawyer, so you can't hold me responsible for my opinions here. I do understand English. I have been following the case from the beginning. I sat in the courtroom for 5 days in October of 2019. I was there. I've interviewed Mr. Younger. I've met James Younger. I've met Jude Younger. I've had the opposing counsel try to take aim at me, Jessica Janicek, try to get me kicked out of the courtroom. So I've been there. I know what's going on here, and I'm sorry, but this is just completely clueless. When it comes down to Evan Young, I think there's a different story going on there, and I'm going to go into that as well. So anyway, the pro se mandamus petition arises from a child custody dispute involving twin boys, one of whom has exhibited confusion about his gender. First off, let me say once again, as I've said many times in the past, this child custody dispute is between a non-biological mother. A non-biological mother, Ann Georgilis, pediatrician Ann Georgilis, who is very LGBTQ friendly, who can be accused perhaps of brainwashing her son to think that he's gender dysphoric and that he's a girl and stuff like that, versus a biological father. This is what's going on here. But Justice Blacklock, the great judge that we have on the Texas Supreme Court, is going to rule in favor of the non-biological mother. Now, I will say this, to the best of my knowledge, Ann Georgilis carried the children. They were not her eggs. So basically, if you carry the children, I guess you now become the mother somehow. Even though you're a non-biological mother, you become the mother just by carrying them. You have the biological father who's fighting for his son who was, I believe he's 9 years old, he may be 10, but he's been confused about this primarily because he's living with his mom. When he lives with his dad, he has never once exhibited these characteristics. He has never once decided that he wanted to be a girl. In fact, he said just the opposite. He wants to be a boy. He wants to live as a boy. He actually plays in boys' activities. He boxes. He's an athletic sort of person. He goes with his father. He wears, to get haircuts. He wears a suit and tie. He dresses like a boy. Only when he is with his mom, his non-biological mother, Ann Georgilis, does he think that he's a girl because of this brainwash that's taking place, because his mother may not love him if he's not a girl, and the mother also dresses him in drag. So this is the case that's going on here. And Justice Blacklock, the clueless Jimmy Blacklock, in his great infinite wisdom here, is going to concur with the court's denial of the petition because the father is already in possession of a court order prohibiting mother from doing precisely what he fears she will do with his son. So the issue at stake is this. Recently in California, Senate Bill 107, they passed a bill that was going to make California like the refuge for these transgender children that needed to have a place of refuge, especially when it comes down to states like Texas that Greg Abbott hates the transgender people, which is also a lie, but this is the type of language that they use, the inflammatory language that they use. Now, Justice Blacklock thinks that, well, we have a court order here. It's kind of like saying, when you tell a criminal, we have a law prohibiting criminals from obtaining guns, and criminals say, oh, okay, we have a law that says we didn't know, so we're going to obey the law. We're not going to get any guns. This lady has been intent on socially transitioning him, and has been intent, I believe, as well, on eventually physically transitioning him, chemically transitioning him, to try to mutilate him. He is a healthy boy, and she wants him to be a girl. Has given him a girl's name, makes him dress up in girls' clothes, makes him wear lipstick, puts girls' hair on him, all sorts of things. This is what the mother does. And Jimmy Blacklock, the clueless Jimmy Blacklock, the guy who I thought was such a great conservative. In fact, I met Jimmy Blacklock about 4 years ago at a Texas Values meeting. Talked with him just for a brief moment. I talked with him and Justice John Devine. By the way, Justice John Devine, the only stalwart on this court, the only person who gets it right, the only dissent to this opinion was Justice John Devine. Perhaps maybe the only uncompromised justice on the court that knows what's going on here. It is such a shame that we have a Texas Supreme Court that will claim to be Republican and conservative and Christian, and we're running on all of these things, and they are just as bad as the Democrats, the progressive communist Democrats that are in our courts, in our family courts in the state of Texas. Anyway, Jimmy Blacklock says, well, the mother already has an order in her hand, and she's going to obey it. Because this is what Mr. Younger wants, but the mother has this court order, and of course, there's nothing that what he's seeking relief from, it's already in effect. He does not want his child castrated. This is child abuse. This is child abuse, Jimmy Blacklock. Jamie Masters, who was the head of DFPS, actually declared that it was child abuse. Not that we needed to have DFPS come and give that opinion. Anybody who's taking a boy and cutting off or mutilating him so that he cannot reproduce in the future, so that he could perhaps confuse him so that he thinks he's a girl, that is child abuse. Jimmy Blacklock, in my opinion right here, is permitting child abuse. Well, this agreed order is binding on both parents and enforceable by contempt. Oh my, here we have, it's enforceable by contempt. So we know that the mother, who has been intent on doing this for the last 7 to 8 years, she's going to obey it because she does not want to be held in contempt of court. And there's a lot of other evidence in here that I'll get into in a future video saying that this is just utter nonsense. And I'm sorry that Jimmy Blacklock was so clueless on this thing. As long as his order is in effect, mother's parental rights, and by the way, non-biological mother's parental rights do not include the right to obtain gender transition therapy for her son. The medical records have shown that that is exactly what she was doing for a few years. And that's, I believe, why Jessica Janicek wanted to have the medical records redacted from the whole writ of mandamus that Mr. Younger submitted. And fortunately, I was able to download it before they were redacted. So we will talk about that and talk about the additional lies that have taken place. Mother freely acknowledges that she is bound by this order in both Texas and California. I'm an honest criminal. I'm an honest criminal. I would not disobey the law when I'm killing somebody. I would not disobey the law as I'm drug running. I would not disobey the law as I'm shooting somebody up. I mean, I'm not going to be in disobedience of the law. Oh, no, we respect our laws. We respect our courts. Clueless Jimmy Blacklock. What kind of nonsense is this that he thinks a mother who's had her mind set on this is going to obey the contempt of court? It's like saying that, we're going to pass laws that say criminals can't possess guns. And they're going to say, oh, okay, we can't possess guns. We'll turn them in. Where should we go? About the only people that would do so would be the law-abiding people, and they shouldn't, because we have a constitutional right to keep our guns. As a result, should she fail to honor her promise, as the father fears, contempt of the district court's order would not be her only concern. What is more, mother has flatly denied to this court that she will seek to evade the district court's order while she is in California. Well, isn't that amazing? Because she's going to be in California. She originally wanted to move to Oregon. So she will freely agree with this order while she's in California. Maybe she's going to move up to Oregon, where it's probably just as easy to get it done. Some of our Supreme Court justices are clueless. And for right now, I'm sorry to say this includes Jimmy Blacklock. Clueless Jimmy Blacklock. As a result, should she fail to honor her promise as father fears, as the medical records indicate she was planning to do, contempt of the district court's order would not be her only concern. Oh, okay, so now here we have a Supreme Court, and we're going to, if she dares deny something that she's told us she flat really wouldn't do, don't do this, because we're gonna come after you. What are they gonna do? Really? It's kind of like when you say, don't cross this line, and the bully crosses the line. Don't cross this line. Don't cross this line. Don't cross this line. This court is clueless. Jimmy Blacklock wrote this opinion. Evan Young concurred with the opinion. 8 Supreme Court justices voted in support of this opinion. Only one, Justice John Devine, dissented against this. Now here comes Jimmy Blacklock. The father misreads California's new law. By my reading of SB 107, well, it's nice that Mr. Blacklock here has an opinion on his reading. Who's to say that his reading is the right reading? Mr. Younger has read the law. We can go to the people that wrote the law, what their intent behind the law was. But Mr. Blacklock, the clueless Jimmy, has a different reading of SB 107. The father's fears are no more likely to be realized in California under SB 107 than they were before the bill's enactment. Clueless Jimmy Blacklock obviously did not read the purpose of this bill. It was to provide transgender kids, supposedly, whatever that is, refuge in the state of California, and especially against mean red states like Texas, where they hate transgender kids. Clueless Jimmy Blacklock, I don't even know what to say about this. And by the way, Clueless Jimmy, what if you're wrong? What if you're wrong? To what degree will you be held accountable for anything? Described by its lead author as a, quote, trans refuge bill designed in part to respond to executive and legislative action in Texas. So Jimmy Blacklock knows this. Clueless Jimmy knows this. The bill certainly casts a wide net in pursuit of its objectives. He acknowledges it, he knows it, he acknowledges it. But of course we have a promise from the mother who has been seeking to transition her son, their son, her non-biological son, for a number of years. And Clueless Jimmy is going to say, but we have a promise. She said she wouldn't do it. We gotta believe her. Trust all women. Isn't that right, Clueless Jimmy? I see no provision in the bill that would alter the enforceability in California of a Texas court order requiring divorced parents to agree before subjecting their child to gender transition therapy. And let me just say this, because Clueless Jimmy just again revealed how clueless he is about this whole thing. The parents are not divorced. Their marriage was annulled. That is another thing in itself. In testimony, Ann Georgula said she was never married to Mr. Younger because her marriage was annulled. Mr. Younger has said that because the marriage was annulled, his children have lost legitimacy. But Clueless Jimmy says that the parents are divorced. I can talk another time perhaps about the annulment process here, but that was another hoax that was taking place. That it's just unbelievable that these things would happen in the state of Texas. Father reads SB 107's prohibitions on the enforcement of another state's law against gender transition therapy as a prohibition of enforcement in California court orders limiting access to such therapy. It is not. Okay, so here it is, Clueless Jimmy, once again, he's going to say, no, it's not that. A court order allocating the parental rights of divorced parents. They're not divorced, Clueless Jimmy. They are not divorced. Their marriage has been annulled. Your opinion sucks. A court order allocating the parental rights of divorced parents based on case-specific judicial findings about the best interests of their children is in no way a law of another state. Well, here we come. Now, Clueless Jimmy is going to invoke the best interest of the children. And I would like to know, Clueless Jimmy Blacklock, please tell us what the best interest of the child means. Please tell us. Because I've spoken with others and they've said, well, the legislature has not given us the definition of the best interest of the child. So we don't even know what the best interest of the child is. And then you talk with the legislators who tell you just that, and they say, well, the Supreme Court gives us the Hawley factors, 8 factors, which are not exhaustive, and there's no weighting attributed to them whatsoever, and these are supposed to help determine what the best interest of the child is. But here he acts as if he knows what the best interest of the child is. Clueless Jimmy, please tell me. Please tell all of us. Please tell the state of Texas. Please tell Mr. Younger what the best interest of the child is. Because according to my reading of this opinion, the best interest of the child is to let the mother escape to California, where she will pursue transitional therapy, child abuse against a son. And you tell me how that is in the best interest of the child. It is not. Clueless Jimmy goes on a little bit further here and says the bill's authors were likely aware. Okay, so now he's speculating. Here we have an opinion by Clueless Jimmy in which he does not even know that the parents are not divorced, but they've actually had their marriage annulled. So they were never married. According to Ann Georgilis, that's in the transcript, Clueless Jimmy. And they were likely aware of the prevailing, now this is speculation, were they or were they not? You tell me, maybe they were. Maybe he's right in his speculation, but it's still speculation. He has an opinion based not only on facts that don't exist, but now on pure speculation. The bill's authors were likely aware of the prevailing interpretation. Now we have an interpretation of the full faith and credit clause, under which states have some leeway to deny enforcement of another state's laws on policy grounds, but little or no leeway to deny enforcement of other states' courts' judgments. Let me say this about this court's judgment part. Even in the state of Texas, you have judgments that have been rendered that courts won't enforce. So that's a bunch of crap. It's a load of crap. If we don't do it in Texas, you think they're going to do it in California? Seriously? This is just nonsense. The U.S. Supreme Court's decisions support no roving public policy exception to the full faith and credit due judgments. Thank you, Jimmy. Clueless Jimmy. Going to continue on a little bit further. Understanding this important distinction, evident throughout the text of Senate Bill 107 between another state's law and the actions of another state's courts, it's essential to correctly understand the very limited extent to which California could refuse recognition of the Dallas County's district court's child custody determinations, even if it wanted to do so. And I will once again say that I've also sat in on some hearings in California. And in fact, if you want to know the truth, I've recorded the hearings. And they've been taken down by YouTube because they were so damning to what was going on down there that the courts actually wrote to YouTube to have the hearings taken down. That's how bad it was. Now, I will tell you, there's another case out there right now with Ted Hidalgo. Talk with Ted Hidalgo, Clueless Jimmy. Ted Hidalgo is going through the same thing. You know how he found out his son was being transitioned by his ex-wife? He received a bill, an insurance bill, for a couple $100,000, and he had no idea what it was about. She was allowed to do that. Now, they were legitimately divorced. They did not have their marriage annulled. They were divorced, and she appeared in front of the judge. I think the judge's name was Judge Hiramoto, who also, I believe, has a son or a daughter who is gender expansive or transgender or something like that. Again, trying to push the agenda. I'm sorry, Jimmy Blacklock, you are completely clueless on this. This is my opinion. This is what I think. And I think that the burden of proof is upon you to prove otherwise. I've seen too many of these cases already. Please tell me how I'm wrong in any of what I'm saying here right now. Well, SB 107 treads close to the territory prohibited by the full faith and credit clause and ultimately may be found to transgress it in various ways. He's actually acknowledging it right here. He's acknowledging that the bill may actually transgress the full faith and credit clause. But we've got a promise from the mother, and she would be held in contempt of court. And something far worse, and she promised she would not take the children to California to get them transitioned in California. Clueless Jimmy Blacklock. This is a disgusting opinion that it almost appears that somebody paid you to write, and for 8 of the justices to actually line up with this. You wonder why we have no faith in our judicial system when the highest court in the state of Texas comes up with garbage crap like this? Wonder no more. It may be found to transgress it, nor does the bill purport to prevent enforcement in California of out-of-state child custody orders establishing which parents may consent to gender transition therapy. And once again, a non-biological mom is going to make the decision about children over the biological dad. To summarize, under an existing Texas court order that mother agreed to it. How clueless can you be? And that mother acknowledges it's binding on her. Oh yes, it's binding on me. I understand it, it's binding on me. Mother lacks the legal right to consent to gender transition therapy for her son, her non-biological son. Can I ask another question of Clueless Jimmy here? Is there gonna be any doctor that's going to say, hey, can you show me the court order that allows you to do this in California? Seriously? Where they're pushing this agenda? This is a bunch of nonsense and garbage. This legal disability, here he comes, as if the legal stuff is everything. This is the problem with our arrogant judges. They're not only clueless, but they think that, well, as long as the legal says it, it will never happen. This legal disability is just as real in California as it is in Texas, and the mother readily acknowledges this as well. Jimmy, do you believe all women? Jimmy, Clueless Jimmy, do you think that women can ever lie? Do you think that Jezebel in the Old Testament was actually a Jezebel, or was she somehow just a naive princess and Ahab corrupted her? Seriously? When a custody order specifies that joint parental consent is required, I guess joint parental consent means one non-biological parent and one biological parent, then a California doctor, just like a Texas doctor, must ensure that the appropriate parents have consented to treatment administered to their children. Do they really think that's going to happen? When was the last time that you took your children into a doctor and the doctor said, can I see the court orders regarding the treatment I'm going to do? Doesn't happen. Any doctor in any state giving gender transition therapy to the father's son without the father's permission would do so without the lawfully required parental consent. Oh, so that's going to stop it. You know, criminals, you're not allowed to have any guns. Hand them all over. We trust you. You don't have any guns, right? We trust you. You readily acknowledge this is the law. Father's further concern is that a California court could undermine the Texas order at the mother's request, and that absolutely can happen. Once again, look at the case of Ted Hidalgo in California right now. It's going on. I met Ted in San Jose, California. I'd heard about him, met him, heard his story, had been in contact with him. Testified on a bill at his request in California. Actually, it was SB 107. Testified against it, and they passed it regardless, because there was a homosexual legislator who wanted to see it passed, if I remember correctly. Father's further concern is that a California court could undermine the Texas order at the mother's request. He points to the following provision of the California law amended by SB 107 as shown in bold. And he goes on further here, a court of this state has temporary emergency jurisdiction if the child is present in this state and the child has been abandoned, or it is necessary in an emergency to protect the child because the child or a sibling or parent of the child is subjected to or threatened with mistreatment or abuse, or because the child has been unable to obtain gender-affirming health care or gender-affirming mental health care, as defined by section 16010.2 of the Welfare and Institutions Code. This is inexcusable, what Jimmy Blacklock did. He points down to right here what the father is saying the state of California permits to have happen. He looks it right in the eye and he says, but we have a mother's promise. A California court is obligated to respect the Texas court's custody orders and cannot modify the Texas court's orders unless the Texas court relinquishes jurisdiction. An action reviewable by mandamus. Well, this was a mandamus. Mandamuses in Texas, by and large, are worthless. It's a waste of time, a waste of money. We have to have a different method in order to find any type of remedy by law, because right now the reality is there is no remedy by law. We've exhausted legal routes, and still, even our Texas Supreme Court, with one exception, Justice John Devine, he's the only exception, the only Supreme Court justice in the state of Texas that we can trust to do the right thing. He's not afraid to be the one person standing against the 8. Father is nevertheless concerned about the above-quoted provision could be used to temporarily authorize gender transition therapy in direct contravention of the Texas order. And yet mother has repeatedly asserted in court that the Texas order is desirable and is in the child's best interest. Once again, the child's best interest. Please, Jimmy Blacklock, tell us what all of this is, which would make it quite difficult for mother to argue the contrary position to a California court, even if it were her intention. She escaped to California. They don't know where she is right now. You think she's going to say I'm in California as a Texas refugee to transition my son because Governor Greg Abbott wouldn't do so, and the court orders say that I can't do that? Do you think she's going to say that really? Or do you think she's already taken up residence and it's just a matter of time? This is abuse. Jimmy Blacklock is an accomplice to abuse. The entire Texas Supreme Court is an accomplice to this abuse, with one exception. The one person with enough backbone and gumption to dissent, Supreme Court Justice John Devine. And now what is even worse is that Clueless Jimmy now gives California a roadmap on how to do just the very thing that Mr. Younger is telling the court is going to happen and that Jimmy Blacklock is saying will not happen. Mother would have to claim that an emergency is so dire that there is no time to ask the Texas court to amend its order. A highly doubtful, and again speculative, a highly doubtful proposition in the age of video hearings. Oh, okay. We can't even get access to these video hearings. How are they going to get access to the video hearings? And by the way, if California can get access to these video hearings, why don't we make all of these video hearings accessible to the public so that we can see where the injustices are taking place? We filed repeatedly against certain judges with the State Commission on Judicial Conduct, and they will not. They don't have access to the video hearings. So Jimmy Blacklock, there is an inconsistency right here. The California court would have to consult with the Texas court. Not if it doesn't go to the court, Jimmy. Not if it doesn't go to the court. And the California court would have to decide to take extraordinarily unusual step of issuing an emergency order directly undermining another state's court order, even though the other state's court was readily available to hear a request to modify the order. So here it is. Clueless Jimmy has now laid out a roadmap for Ann Georgiless to finish this abuse. Concern that any of this will happen would be entirely speculative in any case. This whole frickin' opinion is entirely speculative and not based in fact. In this case, given that the mother has now represented to both this court and the district court that she has no intention of trying to make it happen, it is not merely speculative, but potentially prohibited by principles of estoppel. I don't know what to say about Jimmy Blacklock. Naive, clueless. Maybe he's actually helping California and Ann Georgiless. I don't know. This is the most disgusting, repulsive thing that I have read in a long time. And he claims to be a conservative Christian Republican. And if you are a conservative Christian Republican, quit being duped by the people that claim to be conservative Christian Republicans. We have judges that claim that, we have legislators that claim that. And at this point in time, I think the only thing we can start to do is call them out. I have a number of bills that I want to go over that are supported, sponsored, signed onto by conservative Christian legislators that seem like they're more communist Democratic legislators. I mean, Democrats don't even have to do their work anymore because we have our Christian conservative legislators putting forth nothing but garbage in some of these bills. The court cannot intervene based on tenuous speculation about what other courts might do in the future at the request of a party who may never ask. If the district court modifies the October 2021 order regarding medical care or attempts to acquiesce in a California court's desire to do so, father could seek immediate appellate relief. The father is using every relief that he can. He's gone up to the Texas State Supreme Court, and you guys have been a bunch of numbnuts about this whole thing. That case might raise important questions about whether medically or surgically transitioning a child against the wishes of a fit parent can ever be in the child's best interest. This is not the case. I really don't know what to say about this whole thing. And by the way, Clueless Jimmy, let me just say this. This whole case that took place in September, this was closed to the public. I was there. There were many other people trying to get in. Mary Brown intentionally refused the public access to this hearing. This goes against the backgrounds and legal standards that Judge Roy Ferguson issued under the district court administration, I believe it was, for COVID-19. That in itself, the closure of the courts, was enough to mandate a reversal of the decision. So here you have a justice, a Supreme Court justice, who was saying it's okay that the courts were closed, even though Judge Roy Ferguson, even though the Supreme Court of the United States is against this. I guess Justice Jimmy Blacklock is going to be for this. I don't really know what to say about this thing, but I think that when Jimmy Blacklock comes up for election, that he should not run again. Jimmy, if you, about the only thing you could do to make this right, if you cannot reverse this thing, this horrendously evil, naive, stupid opinion, resign right now in disgrace.